which is the district magistrate in most cases or the divisional commissioner, is meant to be a check upon the powers of the police. But our research shows that this rarely happens. In most cases, district magistrates are doing little more than rubber stamping the dossiers sent to them by the police. What we have found during our research is that the district magistrate and the police are acting together as part of a wider strategy that requires monthly and quarterly quotas of people to be detained. On page 24 is an excerpt from a confidential document which gives you the entire details of a meeting that took place where it was decided to set monthly quotas of overground workers to be detained under the PSA. This was a meeting between page 24 in box number 7. You will see there that between the army, the police and the home and the district magistrate, they are deciding and setting quotas. Now obviously where there are quotas to be made, the risk of framing and fabrication is very high. If a district police has to arrest 200 people every 3 months, they will have to find those 200 people, and if they do not find real 200 people, they will find them from somewhere else. Now, this is very important to keep in mind. The vast number of the PSA cases that we researched, about 60% of the 600 cases, the details again on this page, were found to be alleged overground workers. But also there is a significant number of political leaders and activists who have been detained under the PSA. Now, from the cases, it appears very clearly that the PSA is being used to disable the first and second tiers of the leadership of the major pro-independence political parties, taking them out of circulation, as the senior official himself said, and thereby preventing political mobilization. The grounds of detention in these cases are often vague. They are based on allegations of having made anti-national statements, inflammatory speeches. Although in a number of cases, I should add, there are more serious allegations of instigating mobs and rioting. But the point here is that the allegations are never backed up by any substantial facts or details which allow the person to make a case or to make a defense for themselves. There is little attempt on the part of the police to make out a serious criminal charge, even when they provide serious allegations. Now, we are aware that a large number of political leaders and activists have been or remain in detention. And you will see some of the discussion in quite detail in the report. I think it is chapter 5. Chapter 5. We have discussed in detail the cases of Shabir Ahmad Shah, Masrat Alam, Naeem Khan, as well as the cases of Mia Qayyum and J.N. Shaheen of the J&K High Court Bar Association. But we are aware that the number of leaders is very high, and you'll find much more details in the report there. Also, over the past few years, what we've seen is the resurgence of street protests and stone pelting incidents, with a growing number of youth, including some children, are being detained under the PSA. Here too, importantly, the allegations are vague and general, and few are actually prosecuted for any criminal offence. And it's an important point that even when they are booked under rioting, etc., they are very rarely prosecuted. Where these allegations are making clear offences, we do not understand why the J&K authorities are not seeking to prosecute and follow criminal charges. But it appears to Amnesty International that the J&K authorities are effectively using detention without trial as a punitive measure to punish without trial and have little or no intention of actually prosecuting these individuals. The cases studied by Amnesty International, the 600 cases that we studied, indicate clearly that the authorities in J&K are using the PSA to create a parallel or informal criminal justice system, bypassing the regular criminal justice system to secure long-term detention and thereby depriving people of the human rights protections available in the criminal justice systems. The reason the J&K authorities can get away with this is that the High Court does not make them accountable for such blatant abuse and misuse of the power of PSA detentions. And while there is little doubt that the High Court does play an important role by constantly quashing these detentions, the reluctance of the court to secure the liberty of the detainees in practice and hold the state authorities accountable suggests that the focus is more on procedural and nominal aspects of detention rather than substantive protection of human rights. And in this, we studied at least 160 writ petitions which were filed in the High Court. In none of the cases we found that the court had actually taken action against on complaints of illegal detention, on complaints of custodial torture. In these 160 petitions on PSA cases, we didn't find them. Over the past decade, there has been a marked decrease in the overall numbers of members of armed groups operating in Jammu and Kashmir. By the J&K police's own estimate, now there are only about 500 members of armed groups who are operating in J&K. In the last 5 years, there has also been a resurgence of street protests. However, despite this apparent shift in the nature of the unrest, J&K authorities continue to rely on the PSA rather than attempting to charge and try those who are suspected of committing criminal acts. The existence of the PSA undermines the rule of law and reinforces deeply held perceptions that the police and security forces are above the law. If the government of India and Jammu and Kashmir are serious about the rule of law and human rights in J&K, then there is absolutely no place here for administrative detentions and the lawless PSA. Amnesty International therefore calls upon the government of Jammu and Kashmir to repeal the PSA and end the system of administrative detentions, releasing or charging all detainees. If you are charging them, to try them in a fair trial before a court of law with international safeguards, and also to end all the process of illegal detentions and introduce safeguards for those who are detained, access to relatives, legal counsel, and medical examinations. Amnesty also calls upon the government of J&K and the government of India to carry out an independent, impartial, and comprehensive investigation into allegations of abuse against detainees and their families, including torture and ill treatment. We also call upon the Indian government to invite and support visits of various UN officials, including the UN Special Rapporteur on Torture and the Working Group on Arbitrary Detention. All of these groups have asked for permission from the government of India, but these are still pending. No, on the question of minors, now, this is an interesting one because, as you may have heard the recent Inspector General of Police's statement, Mr. Sahai's statement, where he says that as per the law they can detain boys above the age of 16. That is a deficiency in the Jammu and Kashmir law. And as I pointed out, Jammu and Kashmir is the only place where this is existing. How this has happened, I'll explain to you in 1 minute. India had the Juvenile Justice Act in 1986. Jammu and Kashmir had the Juvenile Act in 1987. In 2000, India signed this UN convention, after which India upgraded the law to a Juvenile Justice Act 2000. Now that is not operating in Kashmir because, as you're well aware, Kashmir has a special constitutional status, it makes its own law. The J&K Assembly has not yet updated the 1987 law. So as of today, in India the age of child is 18 for boy or girl, in J&K for boy it is only 16. Now this is one part of the problem. This is one part of the problem that the J&K police say that under the law we can arrest, the J&K law allows it. So what we have to call, what we are recommending is that this needs to be happening in the J&K Justice Act. That needs to be amended and updated so that firstly this will not happen. But this only covers between the age of 16 and 18. Our research also shows that boys as young as 14 are also being detained. Now obviously that is completely illegal. Now there the question is of how age determination is being done. The police is just deciding on using their own ages. So you will often see references like, he looks 18, he looks 19. Whereas when families are producing birth certificates, very often birth certificates are not available. They bring school certificates, the police is saying that these are not real. So I think that what we need is a better system here of establishing the age as well, where the police is mindful. And actually what we would suggest is that they be taken before a magistrate. If there is any doubt at all, the person looks less than 20, you can tell there is a possibility the person must be immediately taken before the magistrate, who will call for a determination of age.
And one thing that's quite clear is that there appears to be a change in the nature of the opposition to the Indian state. Certainly, there appears to be a clear reduction in the total numbers of members of armed groups who are operating in Kashmir Valley. I think according to the J&K police's own estimates, there are now only about 500 such members of armed groups operating. And we've also seen along the last 4 or 5 years, much more in the last 2 or 3 years, a growing resurgence of street protests, especially with young men, youth, others engaging in marches, in demonstrations, and some of these have turned violent in the sense of stone pelting and fire retaliation or fire by police. So it appears that there are some changes, certainly of this nature. In terms of the operations of the armed forces, I do think that there is more pressure upon the armed forces to respect human rights. Now, the Public Safety Act is a law by which the J&K authority detains hundreds of people every year without trial or charge. So that's why we say these people are held in administrative or what the government calls preventive detention. Though it's not necessarily preventive, these people are held essentially without trial or charge, which means that they're never really produced before a judge. There's no question of evidence, there is no question of defense lawyers, and essentially the point we are trying to make in this report is that by using the PSA, the government is trying to bypass the ordinary criminal justice system. The Public Safety Act violates international human rights law standards, in fact, and has been described by the Supreme Court of India itself as a lawless law as early as 1982, and that's where the title of our report comes from. This report shows not only that the law is lawless, but it further documents the arbitrary and abusive manner in which the J&K authorities practice or implement this law. Detainees held under this law, I mean, the numbers itself range from 8 to 20,000 over the past 2 decades. And in the last year alone, well, 9 months of the last year, from January to September 2010, there were 322 people detained under this law. So the overall number for 2010 may well be over 400. The people who are detained under this law range from political leaders, activists, alleged members or sympathizers of armed groups, and also like lawyers and even young children and youth involved in stone pelting, and they're being detained under this law. So we conducted research with about 600 cases of PSA in the years from 2003 to 2010. And our research shows essentially that the practice of PSA is extremely arbitrary and abusive. One of the most dangerous things about the PSA in Kashmir is that even though the maximum period is provided as 2 years, the J&K authorities effectively hold people for much longer. And they do this by using the practice of successive detentions or serial detentions, where as soon as the court, a high court, or quashes a previous decision, a previous detention order, as soon as that person is released, they are held again. So our main recommendation to the J&K government is that the law is extremely flawed and must be repealed, and they must end the administrative detention system in India, in Kashmir, and all the persons who are held in detention should either be released or they should be charged and tried in a fair trial. Well, we visited Srinagar last year in May 2010 when we were starting with this research on the Public Safety Act. At that time, it was a preliminary idea. We came here, we met with a large number of civil society groups, we met with the Bar Association, we met with lawyers, we met with a large number of political groups, former detainees, some current families of current detainees, and we collected a large number of documents from them relating to the PSA, documents about their cases. In all, we collected about 750 to 800 such cases, of which 600 were finally studied for the report. Now, what this report is based on essentially is government documents, so there's no question of this data being false. Of course, what we do is we don't only rely on data, we also corroborate that data with interviews, etc. And one of the things we asked for was to interview people presently in detention. Unfortunately, that request was not accepted by the J&K government, so we couldn't access any detention facilities. But we do meet with families, with lawyers, whoever it is possible to meet, and we would strongly urge the J&K government to allow us access to the detention facilities. One of the clear things that comes out from the cases we've looked at is there is an unofficial practice that happens that before a person is detained under the PSA, they are normally picked up by the police, sometimes the special operation groups, sometimes the army. They are usually picked up and held informally at these detention centers. So some of these detention centers are quite well known. I mean, everyone knows of the Joint Interrogation Center at Humhuma, everyone knows of the Air Cargo Building. These are well-known names and centers. Now, these people are held at these facilities or in SOG camps elsewhere for about 2 to 12 days at a time. Now, this is completely illegal because they have not been formally arrested and therefore produced before a magistrate, and they are not under PSA detention. So this is like a unofficial, informal detention, secret incommunicado detention, because they are not in touch with their families. Yeah, we met with the Home Secretary on the 17th of March, just before we came to Srinagar to release the report. We gave him an advance copy of the report and we highlighted some of the key recommendations. The Home Secretary said that he had raised many of these concerns with the J&K government, and that they had issued a series of instructions, and that they hoped that there would definitely be positive change with respect to the PSA. When we asked further about it, he indicated that there would be a drop, at least he thought that there would be certainly a drop in PSA detentions in the coming year, to bringing down the numbers to 10 to 20% of the current numbers. So if that is the case, that talks of a 80 to 90% drop in detentions, and that would certainly be welcome. Of course, that doesn't go far enough, because what we would like to see is a complete repeal of the law and releasing or charging all detainees, and not even holding the 10 to 20% that they're talking about. Of course, I should add that he did maintain that it was largely the role of the J&K government to be doing this, as it was a state subject. We are presently trying to meet with the J&K government. We have sought a meeting, and we hope that they will meet with us and tell us their views on the subject and how they intend to proceed further on this report and the recommendations. Okay. In 1997, the Human Rights Committee, when India's report was reviewed, made a couple of suggestions about the administrative detention procedure, and that was with reference to the National Security Act, but it's quite similar to the PSA. And at that time, they had made 2-3 recommendations. They had recommended that the International Committee of the Red Cross, the ICRC, be given access to detention facilities, and they had asked that a central register of detainees under preventive detention laws be maintained. Now, the government did allow the ICRC access since 1995, and we definitely welcome that. However, the recommendation of a centralized register has not been followed by the government, and this is a very big problem, because very often when family members are detained, their information about where they're actually held is not known. So we would really urge the government of J&K to implement this recommendation by the UN committee and initiate a centralized register.